Karnataka High Court had asked the state government to file a reply as to why the police officers questioned juvenile students in the police station. The officers were questioned in this regard after a PIL was filed. Advocate General Prabhulinga Navadgi has filed on behalf of the state government, claiming that the police officers did not interrogate the students but only counseled them. The Karnataka High Court then adjourned the hearing to March 9th, giving time for the complainants to file objections to the report that has been filed by the AG. Supreme Court Advocate KV Dhananjay on the phone line with us. Many thanks for joining us, Mr. Dhananjay. Now, this is the response that has been filed. The Karnataka High Court had asked the state government as to why the police officers had questioned the students. But the response that has been filed is that it was not questioning. It was just, they were trying to speak to them in an attempt to counsel them.
I think this is how the state government gets exposed. Because a number of media stories have said, or rather media articles have very clearly said, that these young children were questioned and interrogated for several hours, for several days. And that is the context in which the PIL was filed to the High Court, in which the PIL was saying that these children, they were being interrogated, and these are all minors, as you are more than aware. If a person is less than 6 years of age, he cannot commit a crime. Even though he might take a gun and then shoot down somebody, that will not be treated as a crime if he is less than 6 years of age. And between 6 and 18 years of age, he is treated as a juvenile and he is not punished like adults. So whatever be the crime that he commits, then for a period of, there's only an observation that he is kept in a remand home for a short time and then released after that. So punishment comes into picture only after 18 years. And so these are young children. And when someone is being questioned, you see, if an adult is being questioned, then the adult, whatever answer the adult gives, then the police could warn the adult and say that, look, if you don't give truthful answers, you will be in trouble. So please give us truthful answers. And in that context, there is a lot of difference between interrogating an adult and interrogating young children. Because young children can't be prosecuted themselves. They also have a very limited role in being witnesses. Now, you can't talk to them for hours together for several days. And so I think there's a likelihood that the government might get now trapped, with its own storytelling. And I think that's how we need to see this as.
That's right. But also, Mr. Dhananjay, the court will only rule on the basis of hard facts and evidence. Apart from a few pictures that are available of the police officials talking to the students as such, there isn't much evidence available that it was indeed interrogation that was taking place. So would that be something that would work in favor of the police officials?
Oh, that's a great question. Now, so far as the police are concerned, what is the kind of counseling the police would anyway do? The event is over. The police don't have any, training to counsel young children. When they go to young children in the uniform, you see, the law presumes that when police actually start talking to young children in their uniform, and that too for hours together, then the children would certainly be very scared. That is why we have set down a protocol, how the police would want to question young children. So yes, you're very right. The courts won't be able to look into the media articles and all that. But when the police at the end of the day have to say how much time they spent with those children and what kind of counseling could they have given for hours together. So everything boils down to whether the police did interact with these children for several hours over several days. If they were to tell the court that for several days, over several hours, they were dealing with these children, then that will have to be construed by the court as a form of interrogation or maybe a kind of intimidation. Now, that's when the consequences will be very serious for the state government. I think that's how we probably will have to look at this.
Okay, all right. So now more time has been given to the complainants to file their objections to this report that has been filed. So after they file their objections, the court will further take up the matter, isn't it?
Yes, exactly. Now, the complainants, at the end of the day, I think it's expected of the complainants to go back to the place and then speak to the management, speak to the parents, speak to the children themselves and find out if the police version is really true. And, at the end of the day, I think it's not just about one school, one thing. It's about the police's accountability while they're dealing with young children, because more crimes are now getting reported in urban areas and the police may not know how really to deal with children. So if the police have committed an error here, then I think it's always welcome if the police were to say that we didn't know the law, we are sorry, we very did something wrong there, we will not repeat it. I think the matter could end that way. But now with whatever version the police have given, I think the petitioners will go back to the school and find out if that version is true, because the petitioners at the end of the day were not really themselves aware of the truth. They were going by the reports in the media, and that is enough. When you're really very concerned, when you're a public spirited citizen, and when you see several media reports that talk about children being hounded, then that's enough for a person to approach the court. And the court has now begun into fact finding, and so I think we will get to know probably by the 9th of March, based on what kind of rejoinder the petitioners will file as to how much of truth is there in the police's version. If the police version is not true, then they will be in great trouble. If the police version is true, then I think we can all feel relieved that they in fact never really questioned or interrogated, and so that's how. That's
Okay.
the test.
Okay. Also, lastly, Mr. Dhananjay, I want to ask you: is it the police's role to counsel these students? A case has been registered in this regard, yes, but they are juvenile. So, the police officials, is it in their role to counsel these students?
Zero. In a case like this, again, a number of lawyers might even say that this is not even a crime where the police could enter the picture. So there is a great deal of doubt whether there is even a crime, because the police might have jumped the gun. So in a case like this, what kind of counseling can they possibly give? This is a school drama, and whatever lessons the children would learn based on the input from the police would not be helpful until they enact another drama next year. So there was really practically nothing for the police to really counsel these children. These were not wayward children.
They've said that a few counselors from the police, from the school, were also present there. Even then, it's not their role.
Well, that's not enough, because children, by the way, are not the property of the school. So if school management was present, that's just not enough at all. You need the guardians and the parents of the children also to be present while children are being questioned, you see. And if the children are not comfortable with the questions, then it's more likely the parent who is, just there next to the child that would be able to say, please stop this, please don't proceed further. So that way the protocol was never really followed, because the protocol cannot be followed unless the parents were there. So with that having been said, counseling, well, basically, it doesn't make any sense. What's counsel anyway? These are not troubled children, by the way. They just actually were given a script and they read it out. Any script they were given, they would have read it out. So there wasn't really much of any scope for counseling here.
Okay. All right. Many thanks, Mr. Dhananjay, for joining us with all those inputs. So, Supreme Court Advocate Mr. K.V. Dhananjay saying now it is for, of course, the complainants to file their response. A report has already been filed by the AG, where the state government has said that the police officers were not interrogating the students as such. They were only counseling them.